Hi, my name is Robert Chelle with Chelle Law, and my law firm assists veterinarians with employment contract and independent contractor agreement issues. Today I'm going to talk about the impact of a non-compete on a veterinarian's career. So, if you are a veterinary associate and you are working for either a vet-owned practice or, as you probably know, more and more venture capital is coming in, gobbling up the vet-owned practices, for these large corporate vet clinic conglomerates. And so if you are in one of those scenarios and you have signed an employment agreement, it very likely contains a non-compete. Now, there are a handful of states where non-competes are completely unenforceable for vets. So if you are in one of those states, you need to identify that you're in one of those states and make certain there is no non-compete. I mean, I guess even if there was, it wouldn't be enforceable. But this discussion is for those vets who are in a state where non-competes are enforceable, assuming they're reasonable. And so a non-compete really contains three things, and these are the things any vet needs to look for in their non-compete. One, it's going to specify exactly what the vet can't do during the restrictive period. It's going to specify, and the restrictive period simply means how long they can't do what is specified. And then there will be a geographic restriction. So for the most part, it's mileage, meaning 5 miles, 10 miles, 20 miles from your practice location. So let's analyze the three kind of components and the things to look for that could maybe come back to bite you. So first, the specialty specifically mentioned in the agreement. So I would suggest that any vet make certain that it is tailored specifically to what you're doing for that employer. Meaning, let's just say you're working at an emergency vet clinic and the non-compete states you can't practice veterinary medicine broadly for 1 year and 10 miles. Well, that's not great for you. So it would be better if it just says you can't practice emergency veterinary care, and then that allows you some opportunity, assuming you want to stay in the area, then it allows you other opportunities. You could just go into general veterinary care. You just have more options, right? So that's the first thing, is make sure that whatever the scope of the non-compete list, that it's specific to what you're doing for that employer. All right, number one. Number two, the length of time. I mean, this one's fairly simple. Most veterinary non-competes are somewhere between 1 to 2 years. Anything over 2 years, I would find, most courts would find completely unreasonable. Now, that doesn't mean they'll throw out the entire non-compete completely. Most courts would then step it down, meaning to the level that they think is reasonable. So let's say you had a 5-year non-compete, which absolutely would not be enforceable almost in any state. They may say, all right, well, 5 years that's crazy, but we think that 1 year is acceptable. And so they may step it down. And also many non-competes have language that literally says that if a court finds 5 years is, not reasonable, then 3 years. And then if a court finds 3 years, then, 2 years, and then it just kind of steps down. So 1 to 2 years is the sweet spot. I would prefer 1 year, obviously, for any of my clients. But most of them will be somewhere between that. And then the geographic restriction is probably the most important language to look at, because it can have kind of maybe the sneakiest ways to hurt the vet. So first, you want to limit it to your primary practice location, meaning it may say, let's just say it's like a corporate-owned vet clinic that has, multiple locations within a city. You want to make certain it says 10 miles or whatever the restriction is from your primary practice location. Some of the clauses will state it's 10 miles from every practice location that the corporation owns within, the county or the city that you're in, whatever. So you could have a relatively reasonable non-compete at 10 miles, but if you add 10 miles to 4 or 5 different locations, it can make it absolutely unreasonable. So that's the first thing you need to look at. Second, let's say there's a scenario where you're a vet that works in multiple clinics. They're going to try to attach it to each clinic that you work at. Once again, it would be, what I would do is probably put language in there that states it only attaches to the location where you spend the majority of your time, meaning like over 50% of your time, or at worst, maybe say 35% of your time, and that way it can only apply to 2 locations. Kind of the, okay, so like the worst example of exploiting this against a vet would be, it's a corporate-owned practice in a big city, so they have like 10 locations, but it states anywhere that the vet has worked within the last 12 months would then apply after the contract terminates. Well, I have found some of those will just, say to the vet, oh, hey, we need, can you fill in this location today? Dr. So-and-so is sick or something like that. And then they'll do that and try to put them at every, as many locations as they can, even one day a year, just so the non-compete will attach to that. If the language says anywhere that you've worked, in the last, or during the term of the contract, last 12 months, whatever it says. So you need to make certain that that kind of exploitation of the language in the contract doesn't happen with you. So what do? How do you make changes to it? Well, obviously you make changes before you sign the contract. So anytime if the employer says, oh yeah, we never enforce this, or oh, we can make changes after the fact, there is no reason for them to make any changes after you sign the contract. So don't take their word for it. You need to make the changes before you sign the agreement. And just point out all of the things I just said to them. Just say, I'm not willing to accept a non-compete that applies to 12 locations because you own 12 locations in the city. It needs to be my primary practice location, or I'm not willing to accept a 3-year non-compete, only a 1-year. So these are the things you can do. And even if the practice says, oh, I'm sorry, we don't negotiate on these terms, or, oh, well, we can't change it for you because then we'd have to change it for everybody. Who cares? This is your contract. At some point, you will need to make a decision of whether it is, I guess, so onerous that you shouldn't accept the job. And there certainly are people that fall under that category. Maybe it's in a city where their family they grew up, they absolutely can't leave. Well, then you need to find a job that has a non-compete that doesn't force you to move out of the city for a period of time. So anyway, that's a kind of brief discussion of non-competes for veterinarians. If you have any questions about your employment agreement or independent contractor agreement, feel free to contact my law firm at the phone number listed below in the description. You can reach us through our website listed below as well. And appreciate you watching the video. Thanks.